Hi, everyone, and welcome to this week's episode of Law Chat with John and Amy. I'm John Yulian.
And I'm Amy Poliafico. This week's question is, what can I do if things have changed since my divorce was finalized?
Okay, well, Amy, welcome back after a week off. So hope everything was good, and welcome everybody. Amy, what type of situations can be modified, or can all situations be modified from a divorce agreement?
So it depends what your divorce agreement or the judgment of divorce says. So most most divorces end in a divorce agreement, not a judgment. So I'll use that as my example. And there's two things that your agreement can say. It can say certain provisions survive your divorce agreement and other provisions merge into your divorce agreement. Um, it's a the judge probably asked you about it at your final hearing. People tend to not really remember. So essentially, if certain provisions, most of the time, such as like your asset division, who's going to keep the house, who's going to get what in retirement accounts, those provisions survive your divorce agreement, which means they are a permanent contract between you and your former spouse, and the court cannot change them. I'm going to put an asterisk, except for like very crazy exceptional circumstances. And then if those provisions merge, most of the time, any provisions regarding kids will merge, which means they merge into the court judgment of divorce, and a judge can then later modify them. So the first thing you're going to want to do if you're thinking, hey, I need to change some section of my divorce agreement, is look to see if that provision survived or merged. And then, John, you want to talk about what happens next?
Sure, and that was a helpful explanation, so thank you. Um, when we think about a modification, um, you have to look at what's the standard that the court's going to be looking for. And as you pointed out, if it's a provision that merges, so for example, as you said, provisions regarding the children, those are going to merge and those can be modified upon a showing of a material change in circumstance since the time you entered the divorce agreement. So, for example, if someone's income has changed, someone might go into court and seek a modification to change the child support order. If someone's availability has changed, uh, something has changed with the other parents, such as maybe they now have some type of drinking problem, maybe getting involved in drugs, that can be grounds for the other side to go in and seek a modification based on, once again, that material change in circumstance, that maybe their job has changed, they have more availability, or because the other side, as I said, maybe has, from their perspective, a drinking problem, or maybe some drug issues. So things like that amount to a material change in circumstance. But that's the first level that has to be met, because if you go in and try to change an order and there has not been a material change in circumstance, the judge isn't even going to address it. So that's the critical piece. So you need a provision that's merged, and you need to show a material change in circumstance for there to be a modification. Amy, can you give some examples beyond what I just touched on?
Um, sure. I mean, someone could want to move out of state, and that's going to impact their parenting plan. Someone gets a new job and their income has changed pretty substantially. Um, a lot of divorce agreements kind of kick off the issue regarding who's going to pay for college, because if you're getting divorced and your kid's 5 years old, you can't really project what's going to happen when your kid is 18 and where you're going to be financially. So a lot of agreements say that you'll meet during the kid's junior year to discuss it. And so come junior year, you're filing a complaint for modification in order to figure out who's going to pay for that if you guys can't agree. And just procedurally, it's a complaint for modifications. There's a summons they need to get served. So it's like a little mini divorce kind of in that way. And you'll have the same structure of court hearings that you would for a typical divorce. But obviously, it's just much more limited to that one change or it could be multiple that you're seeking in your complaint for modification.
But once again, Amy, because you pointed out, it's a complaint for modification. It's not going to be a quick process. Because the other party has to be served. They can file a response. There's going to be, someone can go in and try to get temporary orders, but eventually there's going to need to be a pretrial and seeing if everybody can get to a resolution. But, all of that takes time. So I think that's a good place to finish for today, Amy.
Thanks for joining Law Chat with John and Amy. We look forward to chatting with you again next time. If you have a question or comment, feel free to email us at info@ulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Julian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication. Next time.
Yeah.
Hold on. Let me just see what the...
Amy, I hope you felt the energy I was bringing to the table today.
It was riveting.
Hey, don't get carried away, but I did try to bring a little energy.
Okay.